Risk management. Risk management, by definition, is a non-clinical function that focuses on how to reduce medical, financial, and legal risks to an organization. In a healthcare setting, risk management is used to identify areas of operational and financial risk or loss that could affect the facility, patients, visitors, and the employees. It also is used to implement measures to lessen the effects of unavoidable risks and losses, like incidents or centennial events, and puts in place prevention of the reoccurrence of those risks and losses. Growth and development of risk management. The history of risk management in general and how it grew and developed started after World War II, when large companies and businesses with large amounts of physical assets wanted to protect themselves from loss and risk. They started developing self-insurance against risk, and small business owners as well as other large businesses followed, protecting themselves from financial, physical, operational, and legal risks. Soon, executives in healthcare realized the same self-insurance or risk management principles could be applied in healthcare as well. The growth and development of risk management in healthcare started with the doctrine of charitable immunity. It was created to shield providers and facilities from negligent acts and mistakes. This doctrine was slowly broken down through court decisions on the case of Darling versus Charleston Community Memorial Hospital. Without the doctrine as protection, healthcare institutions became exposed to multiple lawsuits against them, which aided in the development of risk management programs in healthcare. Other forces that pushed the growth of risk management in healthcare were the medical malpractice lawsuits in the 1970s that damaged many healthcare facilities financially. The Joint Commission also began requiring hospitals to implement risk management programs. Patient record requirements in regard to risk management. Proper documentation is stressed heavily in healthcare information professions simply because it is used to prove what did and did not happen and establishes if the proper standard of care was met. This can be crucial in reducing risk and defending a provider in a lawsuit. Proper patient record documentation should be timely complete. All entries should be authored as well as authenticated. The record should meet all content requirements, like correct abbreviations and methods in correcting a mistake. Poorly documented records would be records that are not completed in a timely manner or are not entirely completed at all. Missing author and authentication, as well as things like incorrect abbreviations or fixes made to the record. Security concerns that are involved with patient records include things like availability of the record, having it available for important information in a line of communication about a patient's illness and course of a treatment. Failure to make patient records available could result in patient harm or exposure. Issues related to management of databases and EHRs are also security concern. Security risks in these electronic systems can result in breaches of confidentiality, integrity, and availability of personal health information. Record retention is also an area of concern, simply because are the records being disposed of properly, and is the disposal process as the requirements state? Information disposed of incorrectly could result in security breaches on patient health information. Confidentiality of the patient information is kept by staying true to an obligation a provider has made to maintain patient information private at all times. This means being aware of to whom and when you are talking about private patient information. Take precautions always when dealing with this kind of personal health information. Not doing so can end up in confidentiality breaches that can lead to lawsuits that can also lead to major loss for the facility or provider involved. Incident reports. An incident report is the documentation of an adverse incident, whether it be on paper or through a computerized database with high access control. The report includes the incident itself, the time it happened, the date it happened, the place of occurrence, along with the condition of the subject of the incident, whether it be a patient, employee, or visitor. They are necessary to document the incident fully, educate healthcare professionals from a reoccurrence of the incident, and to add to a database of the number and types of incidents that have occurred. Incident reports continued. The incident report should be completed as soon as possible after the incident has happened, when the memory is fresh. By completing the report in a timely manner, the healthcare provider can get the report to their attorney, insurance carrier, as well as the quality assurance department for review and evaluation. The report is one of the most important reports used in lawsuits against provider because it contains the details of the event that caused an injury and exactly how it happened. You can protect incident reports from being used in a trial or court as evidence by privileges. A privilege is a legal right to keep certain information confidential and protect it from being used. Examples of privileges would be an attorney-client privilege, which I will briefly explain in the next slide, and attorney work product privilege, which is not commonly used in healthcare content cases. An attorney-client privilege. The attorney-client privilege is a privilege that protects all communication made between attorneys and their clients from disclosure to third parties. This means all communication is kept confidential. It is meant to facilitate full and open communication by ensuring the confidentiality. In order to fall within this privilege, there must be an attorney-client relationship established, and the client must make the communication in confidence for the main purpose of obtaining meaningful legal advice from the attorney.